Thanks for joining this episode of our webinar series on best practices in e-discovery, GenAI, and digital forensics. Today's session is going to be packed full of great information. We're currently in the middle of a legal tech renaissance due to the rapid emergence of generative artificial intelligence. This is having a massive impact in e-discovery and across the entire legal services industry. My name is Jeff Fugit. I'm the Chief Revenue Officer for Lexby, and I'll be the moderator for today's event. We've got a lot of information to cover, and I'm going to jump right in. Our webinars take place monthly and cover a variety of relevant e-discovery, GenAI, and digital forensic topics, trends, best practices, and strategies. We've got limited seating, so be sure to register early for the sessions that are of interest to you. If you have technical issues or questions, please email us at webinars@lexby.com and we'll address those right away. Our webinars are available online at lexby.com for viewing via streaming video or downloadable as a PDF presentation or MP3 podcast. You'll find this webinar and a complete listing of other webinars at lexby.com or on our YouTube channel. If you have any questions during today's session, please enter them in the Q&A portion of the GoToWebinar console, and we'll answer them after the event. To be notified of future live and on-demand events, please email us at webinars@lexby.com or follow us on LinkedIn. For more than 18 years, Lexby's been helping legal teams handle document-intensive matters. Nearly 9,000 legal professionals have come to rely on Lexby's state-of-the-art e-discovery platform and professional services. We have the industry's most affordable, full-featured, cloud-based e-discovery platform, including integrations with ChatGPT and other generative AI models. We've also launched a GenAI product called Lexby Autopilot that is automated document review, which is better than TAR, gives you a confidence score, the rationale for the prediction, and has delivered outstanding scores for precision and recall. We have the industry's fastest e-discovery processing and document review capability. We're consistently rated as having the best customer service and support, the easiest to administer, and the easiest to do business with. If you'd like a demonstration of our platform, simply email us at sales@lexby.com and we'll get that scheduled for you. Joining us today are two outstanding guest speakers, Gene Albert, CEO of Lexby, and Judge Xavier Rodriguez, United States District Judge. I'm going to let them introduce themselves because we've got a lot to cover today, but before I turn it over to Gene, I'm going to ask for your participation in a quick polling question. Are you currently investigating how you can utilize generative AI in your organization? And while you're answering that, I'll thank you for participating in our polling questions today. All right, I'll go ahead and close that poll. And without further ado, I'll turn it over to Gene Albert. Gene?
Hello, I'm Gene Albert, CEO of Lexby, and welcome to another edition of the Lexby e-discovery webinar series. And we're very happy to have Judge Rodriguez participating on this webinar. Judge Rodriguez is the U.S. District Judge for the Western District of Texas. He's formerly a Texas Supreme Court Justice, and before then a partner at Fulbright Jaworski, now Norton Rose Fulbright. He was very well educated at Harvard undergrad, a master's at the LBJ School of Public Affairs, JD from the University of Texas Law School, and Master of Laws from Duke. Where we know Judge Rodriguez, he's been very active in e-discovery education and writing, and is a leading authority. Recently edited the Essentials of E-Discovery in 2021 by the Texas Bar. He's on the Sedona Conference Advisory Board and is an adjunct professor teaching e-discovery at St. Mary's Law School. Recently has been very involved in generative AI topics and the relation to the law generally and e-discovery in particular. And in particular wrote a wonderful paper that is at the Sedona Conference Journal for Artificial Intelligence in the Practice of the Law. Judge Rodriguez, that been released yet, or is that still?
It has been released.
Yeah.
And so, you can go to the Sedona conference and it's online, publicized there.
Right. And then we'll have a link to that as well that you can log in and download it. I recommend it for everybody. I think it's absolutely the best thing that just covers all of the emerging issues that we have coming up, generative AI, and Judge Rodriguez takes some positions on where he thinks some of this stuff may go, but a lot of it's just kind of opening up the issues, and I think it's going to be incredibly interesting what's going to happen in the law here going forward on it. He recently also did a presentation at the University of Florida for that e-discovery conference as well, and is going to cover some of the materials for us, and has some a PowerPoint that goes through much of the material that's in more detail in the paper. So I'd recommend both. And the format here is we'll jump in and go through that, and then I'll have some questions, and we'll have some discussion. But there's a ton of really good substantive materials just to raise the issues and address where things are going to go with the practice of law. So with that, I will turn things over to you, Judge Rodriguez. Thank you again for doing this with us.
No, not at all. My pleasure. So I'm going to go through some of these slides relatively quickly so we can be talking about AI and e-discovery more focused. But along the way, I encourage Gene to interject and ask me some questions, stop me, perhaps ask the questions that you would have asked. And so we'll try to make this interactive here. So this generative AI, this AI world in full, if you're confused, join the crowd, because everybody's confused about what's going on here right now. We're in a brave new world. We got two competing heads here talking. We got the founder of OpenAI contending that all this artificial intelligence should be regulated. Government should be involved in this regulatory process because left unchecked, there could be dangers abounding in the artificial intelligence world to come. And on the other end, we've got our friend who thinks that everything ought to be interwoven into the metaverse, artificial intelligence, visors, chips. I'm not sure where he's taking us. And so we've got competing visions of what could happen here with the world that we're exploring today. And then we got some people who think, been here, done that. This is just going to come and go, no big deal. And so we had some of those kind of players way back in late 1999, early 2000s, saying that the internet was just going to be a passing fad. So we all know how that ended up. The internet wasn't a passing fad, and I don't believe AI is going to be either. Although there's some folks who are taking a whole bunch of contradictory positions on this. Some folks think this is not ready yet for prime time. Some believe that, oh my goodness, the use of this technology, especially in military applications, is going to blow us all up. And then in the e-discovery world, we have some very prominent names contending that artificial intelligence and AI has yet to been validated in any kind of scientific way. And so we have skeptics here in some circles. I got to say, personally, where I stand on that, I'm not that much of a skeptic. Whatever concerns AI might pose to us, and it does pose concerns to us. In the military context, I'm not here to say what the government's going to be using this for, but we probably ought to have it regulated in some fashion in that context. But in our world, e-discovery, I am cautiously optimistic is where I'm going to start. I think there's going to be potentially a lot of value in cost reductions that we might bring to bear that will hopefully reduce the cost of litigation and see if we can get justice at a price that we can all afford. So with that being my cautiously optimistic view on this, let's talk about AI big picture, and then we're going to whittle down a little bit into how AI gets into the e-discovery world. So AI big picture, and all the talking heads can't agree to a definition on this. There are some who contend that there's a lot of people advertising stuff that's not really AI, and that may or may not be true. I know the Federal Trade Commission just issued some guidance on prosecuting some players for fraudulent and deceptive advertising practices, claiming whatever product they have is not really AI. And so if there's a consensus on what AI is, it's this. an AI tool does abstraction, reasoning, problem solving, and so there's a number of different AI tools out there. That's one big picture I want you all to walk away with. There's a lot of AI tools. They may not all be what we're going to be talking about when we talk about e-discovery and how the legal industry is going to use it. That's going to be a specific subset. Big picture, though, in the big picture world, all AI tools are basically this. They're large data sets, either text, when we talk about large language models, or audio, or video, or in the context of the healthcare industry, just think of lots of MRIs, lots of CT scans, lots of X-rays. It's large amounts of data. Big picture, large amounts of data are applied to algorithms. Not all algorithms are alike. So when we talk about the e-discovery world and the rest of the AI world, for that matter, all these algorithms are designed differently, weighed differently. There might be different weights. But when we're talking about language models, which is what we're going to basically see in the legal industry, even then, these algorithms operate differently. We got large data set. Think of scraping the internet and scraping all the possible words out there, applying it to an algorithm. Each of these algorithms operate differently. Some will weigh some correlations different than others, but the large data works through an algorithm, and then the algorithm comes up with predictions. And so let's stop there and let's break that down. It's not thinking yet. Some people think that the AI will eventually get to thinking. Others say we're never going to get there. Yet others say, hey, maybe they'll get there one day, but probably not in the lifetime of any of us here. Who knows? Lots of developments in this area in a very short period of time. But let's talk about the here and now. It's making predictions. AI is not lying to us. It's not telling us the truth. It's just making a prediction based upon what the algorithm thinks should be the next logical token. And so then let's talk about this word token I just introduced. These AI tools operate on the basis of tokens. And so these algorithms come up and come up with what the next likely token is going to be. Think of token as part of a word. And so, just loosely talking right now, let's sort of interchangeably use the word token and word is the same thing. I want you to know, though, token is actually less than a word. But it's making predictions. Now, one thing about these AI tools, and this is not anything new. We've been doing AI for a little bit now. And so, for those of us in the legal industry, we've seen machine learning tools come up with looking for patterns, and then on the basis of patterns, coming up with a prediction. But humans have always been involved in this. And so in predictive coding or technology-assisted review, for those of you who have not used one of these tools, what we have is a human reviewer. The human reviewer, I'm going to give just a hypothetical, I'm making up these numbers. Let's say the TAR tool says you should review 5,000 documents out of this corpus of 1 million documents. So a human reviewer will review 5,000 documents for responsive, not responsive, responsive, not responsive. And on the basis of how the TAR tool has been taught, it's now learning that with regard to the remaining part of the corpus that no one has looked at, no human has reviewed, based upon what the human reviewer taught the TAR tool then automatically will generate, based upon how it's been taught, what the rest of the corpus should be looking like in terms of responsiveness and non-responsiveness. And no human reviewer ever actually saw the rest of that data set as it went through that process. And so it's been working pretty good. And that was an earlier form of an AI tool. Where are we headed now?
Judge Rodriguez, if I could interrupt you on that with a question. With the tar-based tools that have been out, they certainly have not been adopted at the rate that the initial people in the industry thought it would be, and we've all sort of puzzled why that was. I mean, it is different here in the sense that those old ones were rule-based, and at least in principle, if not in actuality, somebody could tease apart the algorithm and see what was really being done with that. And then some of them were fairly brute force algorithms that you understood the logic of weighing words and stuff, not perfect. When we're over on these AI ones, because it works with languages on a probabilistic model, it is inferring something that looks very, very much like logical inference. And we struggle to differentiate at principle what's different than that than what the human is actually doing. So it certainly, it goes from being something that we, at least in principle, could have understood to where with the neural networks is off to something that looks similar because it's like the human brain. So we do seem to be in a different world here with things than we've had with the old technology.
Yeah, no, you're absolutely right. And so let me address those questions now.
Oh, sorry to bounce you around on the.
Oh, no, not at all. I'd rather have this back and forth. So,
yeah, how
is a Gen AI? And we're talking now about generative AI. Remember, I said there were a whole bunch of different AI tools. We're in a world of generative AI. What for the legal industry? And what we mean by generative AI is you're going to type in a prompt. For those of you who have not done this, and I'll pass on the slide deck to Gene, and he can forward it on to all of you all. I've got a prompt.
Oh, great.
A link in an earlier slide. If you wouldn't go to there, it'll take you in a YouTube that shows you how the prompt and the response works. And so basically, you come up with a prompt, think query, that we call it a prompt in the AI world, and you type in the prompt. The better the prompt, the better the response is going to be. But you type in the prompt, and then a response gets automatically generated, and that link will show you how quickly this all takes place. How is this different than TAR? So I told you that in TAR, we actually had a human doing review on a small subset, and then the TAR machine learned on the larger subset what was responsive and not responsive. How we verified this was we could generally look at the documents that were called to be unresponsive and do a sampling on that unresponsive set in the TAR process. And by doing a sampling, we could assure ourselves that, yes, the TAR tool accurately predicted 80% of the time responsive versus non-responsive. And we could assure ourselves that the TAR tool worked good enough. Because we have to remember, the standard's not perfection. It's not 100%. We never required that in this AI world. So a lot of the e-discovery vendors are now introducing AI into their tool set. Here's where we're going to have some problems, and you're already alluding to them, Jim. How are we going to satisfy ourselves that when we typed in a prompt into the AI e-discovery tool and said in the prompt, please provide me all documents responsive to request for production number 1, which reads as follows, and or something like that, then the AI tool is automatically, with no human intervention, going to pull what it believes are responsive documents. Because of this neural network that works sort of like our brains and this predictive algorithm process, the AI tool, AI e-discovery tool, is going to produce a response. We and you all in this e-discovery vendor world know better than I do. You know, sometimes we can't explain, or at least I haven't seen satisfactory explanations about what happens in that neural network / AI process, because sometimes you can ask the same response and, type in the same prompt and you get a slightly different response, which in our world, you know, legal caution and concern about compliance and it makes us kind of uneasy. And so that's a problem. The other problem is going to be verification. So in the TAR process, we could do sampling of the non-responsive set and see whether or not we were good. What are we going to do here in this AI e-discovery world? So some folks have been doing studies already. There's been a study by, I'm sorry, I just came out of a trial, so I'm brain fried. Redgrave Data. Redgrave Data did a analysis of production, and the analysis they did was on a data set they had done a old school human review for. And then they compared that old school human review with what the AI tool that they were running on this study, and basically came to the conclusion, hey, did pretty good. Yeah, it was it 100%? No, but by and large, the AI tool performed satisfactorily. Now, trouble is, in our verification world, we can't do that with every data set, right? That's a complete waste of effort. We're not going to be able to run an AI tool and do an old school production on every case, because that's just not, that doesn't make any economic sense. And so I think what e-discovery vendors are going to need to help us in the court system and with litigants is how are we going to demonstrate good enough of a production in an AI-driven world, or is there going to be some mechanism for some kind of second-tier review of what the AI tool did and figure out whether or not there was an adequate recall and precision, if we're going to use those terms from the TAR world into this AI world. But yeah, you're hitting it right on the head, Gene. We're going into uncharted territory, and that's what I'm a little concerned about.
If I could ask a general question before we get into the tools and the case law, and I agree with your assessment of it. When we did TAR, when TAR came in, we were all suspicious of it. It was new. It seemed to be a black box, even though it's rule-based. And we put these overlays on it of doing the statistical sampling. And certainly as lawyers, I mean, it would be good for all of us to understand statistics. I don't know anybody that thinks they know too much statistics, that does any kind of business or law. It's just a critical tool to have in there. So I'm not anti-statistics at all. And I'm glad I know what I know, and I wish I knew more. But to generalize that across the entire production process, I mean, we don't do that generally. I mean, when somebody produces in a case, nobody has looked at all of the documents hands-on. So we've got a gold standard supposedly, and we could talk about that, how gold that standard is. I mean, you and I could review documents and come up with different opinions, or probably better, but many lawyers would have different opinions on that who are human. So there's not one human gold standard. Once you move into the technology of that, there's a question of how far you go with having to validate it statistically. When we're normally doing things, we don't look at every document. We run searches on things. Most productions go out without TAR. They go out with searches, and we do search technology. It goes out the door. You have a Rule 11 certification. I think it's very clear in our and other initial testing that just using the GenAI versus doing a search methodology, and certainly a human methodology, and the TAR as well. This GenAI, at least on accuracy and explainability, holds up with all those and does better than what the other ones do. And of course, there's a difference of input. You're going to get different answers. I mean, if I ask somebody, a lawyer, to research something, in the morning or the afternoon, I'm going to explain it a little bit differently. We may get a little bit different output from that later. Different people may do it differently. There's going to be different opinions. I mean, that's all what we have now. So it seems like we're trying to make it into a perfection standard at the time when it's not, when it's anything but that's being replaced simply because of our suspicion of new technology. And that would be a bad road to go down too far.
Yeah, I can't disagree with any of that. That's absolutely right. And that's why I'm cautiously optimistic. I mean, this stuff can get us to where we want to be. So the gold standard. The gold standard what we're referring to is manual, hands-on, eye on paper review. So lawyers looking at every piece of paper and saying responsive, not responsive, privileged, not privileged. Supposedly that was called the gold standard. But then Mara Grossman and others did a study a while back, indicated quite persuasively that the gold standard actually is not the gold standard because of human subjectivity, because of human tiredness, fatigue, hunger. I don't care. Whatever might happen there while humans are doing work, there's a lot of mistakes made. And so Mara Grossman and her colleagues very rigorously demonstrated how the gold standard doesn't get it right. And compared to TAR, predictive coding, TAR performed better than the gold standard. So now we move into this world now of GenAI related discovery tools. And there's already some studies being published that the AI tool is doing a much better job in terms of accuracy for coding. And that sort of makes sense, right? You know, these machines don't get tired, they don't get fatigued, their eyes don't glaze over. And so that doesn't shock me that in terms of coding, they're already doing a better job with more predictability and reliability across the spectrum. But where are we at now? So, you know, to finish the thought on that, you know, De Silva Moore was back in 2012. That was Judge Heck's order where he recognized predictive coding in TAR as an e-discovery tool with reliability. And here it is. God, we're in 2024 now. We're 12 years past that. And TAR never took off the way we expected it to. You make that point earlier, Jim. We all thought that, you know, TAR tools were going to get us over the never-ending conundrum that we had, but there's more and more data being produced that has to be reviewed. And we're getting to a point in a lot of cases, it's just impossible for a human to review all the data. So we're going to need technology to assist us. But then the fight's done. It's generally the requesting party going, well, is this tool reliable? I want to be at the table with you when you're doing your searches. I want to be able to, you know, see the seed set that the TAR tool was trained on. What is the recall precision? Let's develop some protocols here. And regrettably, it was just nothing but endless fights in all that, those steps I just outlined. And it got to the point that I think a lot of litigants said, the heck with it, we're not going to use TAR. We're spending too much fighting with the other side over the use of the TAR product, and we just won't use it. I am a little concerned that in at least in the short term, AI tools are going to start with that same fight all over again. This is going to be the TAR, the new version of TAR Wars, pun intended. And so that's not good for the system because there's too much data to review. It's too costly to review. And where I'm hoping that these tools will take us, I'm hoping it takes us to early case assessment. If we can get these documents off the systems of our various clients, we put them into an e-discovery AI tool, we run a prompt, and we get initially an identification of the key documents in the case, and we're required to share them with the other side initially. It may not be a full production. It may not be the complete request for production that we're used to, but we get an early assessment of the hot docs and share them with the other side. Maybe we could get to the point of everybody sizing up their case earlier because we all know full well that a lot of these documents never ever actually get used down the road in the litigation process. That's where I'm hoping these tools take us.
And you mentioned that this in your paper in the deck as well. I mean, it's very interesting, the Sullivan and Cromwell project of developing call it layer AI, but the idea that you would have an AI tool that had been trained on your case sitting at your deposition it would have ingested all of the information. It would know the case. It would tell you what you missed before you did that. I mean, theoretically, it'd be very easy for us to incrementally try to change the processes that we've been working with under the burden of increasing document size and types over the years, and not take a really new, different cut of what we're going to do with e-discovery. So the idea that you could flip it and really have something that would be a true co-pilot, working with you as a lawyer.
Yeah, no, I find that fascinating what they're doing. I haven't found out whether Sullivan and Cromwell, I mean, I guess they wouldn't have publicly announced what they were doing unless they were going to license it out to third parties, or unless they're using this as a strict marketing device, and it's not going to be marketed out. But here's what they're doing. So and this leads me to, I think, a good segue into another topic I want to talk about. So let me backtrack first. So we were talking about GenAI. Generally, everybody knows that as ChatGPT. I'm going to use that as the shortcut, almost like Xerox, because that's where we're sort of at right now. There's a whole bunch of different AI tools out there. But ChatGPT got the most notoriety early out in the box. And so that's what a lot of people are already familiar with. ChatGPT is uncurated. By that I mean, it extracted data and documents from everywhere. We're getting to the point now, we're getting through something called GAN, G-A-N, we're getting curated databases. And that's going to be important for the legal industry, because uncurated, the ChatGPT world at large ended up hallucinating a lot. And well, not a lot, that's bad. A little in its earlier versions, it's getting better. But remember, ChatGPT, we use that generically. All these AI tools, they don't lie, they don't cheat, they don't tell the truth. They're just doing predictions. And in the predictive capabilities, sometimes it makes mistakes. It's called hallucinations in the AI world. And so some lawyers have been relying upon these uncurated AI tools to do legal research, and notably mistakes were made. First thing is, these things are tools and not final products. Lawyers need to be checking the accuracy of whatever the response is. So that was bad on the lawyers not doing that. I do not fault the AI tool. Now, what lawyers should be moving towards now in this point in time is GAN curated products. And so GAN curated products are now, instead of taking the whole body of works, are now curated for the legal industry. They're taking all the statutes, they're taking all the cases, regulations, CFRs, etc. And so the chances of hallucination have dropped dramatically because of the training module being curated. Now, it's still going to make mistakes. It's still going to hallucinate, perhaps less. And the quality of AI tools are improving rapidly every day, week, month. And so it's going to get better. And so what Sullivan and Cromwell done is they've taken this one step further. What's happening is, in this product they're calling LAER, they're going to put the entirety of whatever case they're working on. It's going to reside on your laptop. And you will take now that laptop that has, I'm sure it's cloud-based, but it's you're going to take that laptop and you're going to go to a deposition, and you're going to put a mic on the table, and Layer is going to listen to the deposition in real time. And as it's listening to the questions, it's going to suggest to the lawyer additional questions or documents to raise during the deposition, and all this is happening in real time. And what they think they're going to do with this product is, even take it all the way up to trial, where the lawyer will suggest perhaps closing arguments, suggest questions. But just remember, these are tools. And just because the AI tools suggest you do something doesn't necessarily mean that you should do it. You have to exercise your professional judgment, and whether or not you ask that question, whether you build this extra document. Yeah, this is taking us to, I think, really neat places. It could also help us out with nonprofit work. So a lot of pro bono providers and legal aid entities, the need out there is too great. They can't fulfill it. So could they have chatbots that perhaps expand the services they render? It comes in with a lot of questions about the unauthorized practice of law. And I really don't want to get into all that with you all unless you want to. It's got issues, our ethics restrictions that we need to work through. But my point here is this stuff could do us a lot of good if it's used responsibly and we use it as a tool and not the final product.
And if I could just comment on that, my feeling is that the issue with the hallucinations, this is really nothing new for us. I mean, we've always had false positives. There's always a trade-off between your algorithms, whether it's the human or it's doing a machine, and things need to be tested. And we do that all the time informally in the legal process. And it's called professional discretion. And anybody who does their legal research and their shepherdizing on the AI tool just isn't understanding what it is or they're doing. And we may get more of that because it's available, and that's going to cause a lot of issues for the legal system. But it's not anything in principle different than we're dealing with all the time with everything. On the data, and I wanted to comment on the databases too. That's an interesting point. Certainly, people are selling curated databases. They're pulling everything in. So there's so much marketing that's going on in the hype on things here. But what made these tools start to get very good as they got to the later versions is they did incorporate in larger neural networks way more material, good or bad. And they took every book that they could find, and we've got the copyright suits that are going through and everything. So that span gives the power of the inductive reasoning, and the inferences that we're able to do that really makes this thing, shine now in the later versions of it. So to the extent people pull those databases back, yeah, they're going to get rid of some false positives and the hallucinations, but they're also going to lose a lot of the power that allowed for the inferences to be made that makes it seem like a human lawyer reasoning and everything else. So we're not at all convinced that direction is going to be the better direction for getting better logic out of these machines as they go forward. And our money's on, the big public engines that have put all the research in and everything in for giving us the best logic out of it.
So, let me tackle the hallucinations first, and then the second part. So on the hallucinations, absolutely right. And this is where I've been trying to convince my colleagues, don't be entering these orders that seem to be vaguely threatening, don't use AI. There's some judges who basically say you can't use AI. We're using AI in the big picture when they really mean generative. There's some judges who say, if you're going to use GenAI, you need to disclose that you're using it. I've been telling my colleagues, guys, this is not where we should be heading. We shouldn't be killing the product before it already goes out. And by the way, your orders are already stale. Because Westlaw Precision, Lexis AI, they've already got AI tools in there. And do you really want to be notified every time somebody orders using Westlaw? I mean, it's just not. So, and then the other parting shot I think I give in a joking way is lawyers have been hallucinating for a long time without AI tools. And so, we've had some lawyers.
That's why we call it the bar, right? The bar. Hallucinating at the bar. Right.
So, they read a case and everybody else in the room is like, that doesn't stand for that. And so, it's a tool. And once you verify the tool, then we're okay. To your second point, so that raises a really interesting question. There's some platforms, and you all in the industry know better than I do, that are running their prompts through a GAN and curated material, and then running it against the large language model data set. And so I think that's what they contend gets the better product. There's some that are brain in a jar and it's all contained. it'll be curious to see what are these three differing versions that are out there and how this all plays out. I don't pretend to know the weeds in that detail.
Well, and there's some pretty damn big weeds. I've got to say on that, and I think the prompt engineering is going to be so interesting. I mean, my own feeling, there are differences on how you describe it and what you get back. I mean, it is sensitive to the way it's phrased, but it is when we talk. I mean, a slight difference in how we would describe something talking to somebody else. Yeah, you're going to get some different outputs on that, and it gets more complicated and it's nonlinear. So this is something that we've had in the past. So I'm not sure it really deserves to be treated that much differently, in these AI engines. And what these things do is that's the price we're paying for getting that human-like inductive inferential reasoning that gives explanations and makes it so much more powerful than the old tar tools and the other things that was just pretty much you put it in there and you get an answer, but you have no idea other than it was rule-based how it got to the reasoning because it didn't use a human-like process. Where now we have a human-type process that we can say, why did you think that document is responsive? And it will give you a reason, and it's a credible reason, and it's a good reason. I mean, we're just amazed at how well it does that. So I think that's really what's making the sea change, among those of us in the industry that are doing the testing on these tools and these approaches.
You know what? And so you were thinking, talking, it made me advance a couple of slides. I think you've hit it on the head about what's scaring lawyers and judges, though. It's this human-like quality to this, and I think people are afraid they're going to get replaced. I think so. A lot of concern about lawyers going, hey, wait a minute, our paradigm is being impacted here. Our profit centers were through the discovery process and litigation, and that's scary. What am I going to do with associates? That's scary. And so I think even judges, I don't think judges are all that scared about being replaced in the United States. But I'll hold that thought. I'll share with you guys in a moment what's going on. But, it's understandably, everybody's always nervous about the unknown, the untested, the future. And this is where, okay, I don't think this is going to displace lawyers. In the near term, I don't think there's going to be much impact at all. The next 5 years or so, or we're going to need probably less lawyers, less paralegals, maybe so. But I don't think we're anytime soon in a position that we're going to lose a lot of legal staff here. A lot of what we do is handling, right? We have a client, they've got to be kept abreast, they've got to be sold. And so that's not going to go away. Humans still need to do the fact checking. And this stuff is generative AI. It's creating something new, but it's not necessarily creative, at least for legal documents. It might be creative in doing art, but it'll help us with getting to creative solutions. But the creativity part still, by and large, human-driven here. So, hey, but by the way, I sort of mentioned what's happening to judges. Now, where I don't want to see this head. So China is running some interesting internet courts, is what they call it. And so far they're in 2 cities. And it's a combination of GenAI and metaverse. And so you go into a metaverse site, you create an avatar of yourself, and you upload whatever you want to upload in the case. The other side does the same thing. And the other avatar is not a judge, it's AI. And they claim they're doing this for breach of contract, patent cases, family law, a whole litany of things. And they're claiming that from date of initiation to date of conclusion is 28 days. Now, I'm not going to say anything critical of their judicial system. They've got population issues that we don't, and they've got a different system and custom for the rule of law. Here in the United States, I don't think we're ever going to go that way. But, it could be an interesting challenge for us in the United States. Could we use AI tools to expedite our process, get these early case assessments out, help with the mediation process, help with individuals who are not represented, which is a big problem in state courts. and even to some degree federal courts. This could be a good augment tool, and it's not going to be anything like the Chinese model, but it could help us in many ways.
It's so easy to react to the negative worries about things. It's great to see the optimistic view of it as well. With your class at St. Mary's or with law students, I mean, maybe that'd be an appropriate place to say, I mean, what would you say to somebody for a new law student, what they ought to be thinking about developing their skills so they're better able to be leveraged, to have their time leveraged with these tools properly rather than doing it the old-fashioned way or being, hit by this later when it finally gets adopted more generally?
Yeah. So, the first thing I would say is I wouldn't be specializing right now. From what I know right now, I wouldn't be specializing and spending a lot of training on becoming a prompt engineer. So let me go back to some of the audience. So we enter these prompts into our AI tool, and it generates the response. Earlier versions of these tools, it was almost like early versions of Westlaw. You needed to know the syntax. Mm-hmm. You needed to make sure that within 5 and quotation marks were exact, and there wasn't a missing parentheses. And so the early versions of a lot of the GPT tools had a lot of these syntax problems too. And it had a lot of issues with, if you were minimal in information in your prompt, well, the tool struggled to give you a very, very good answer. And so, but we're progressing almost monthly here with these tools. And so 6 months ago, everybody said, oh, well, you're going to need to be a prompt engineer. I personally, and Gene, you know better than I do, I think we're moving to a world very quickly where this is going to be almost Star Trek. For those of us of that generation, you go, you're Kirk, and you go computer, and you ask the computer a question, and then the computer gives you the answer. We're already seeing a microphone feature for the prompt in some of this AI tools, and I think that's where we're headed very quickly. And so you'll just be able to talk to your AI tool just like you were a regular person talking to another regular person, and the quality of your prompt will actually be increased by that. Now, the more factual you can get, the more detailed and all that, just like you think about it as you were just talking to a brand new associate. We don't start at high level. We go walk and talk them through step by step by step. You'll do that with the prompt. And I think that's the world we're going in. And that's what I would tell my law students. Don't spend a lot of time on prompt engineering. Do you agree? Disagree?
I agree 100%. I mean, there's amazing over marketing in this industry, on different things, and we kind of get caught on different things, and they get their own way. So it's the prompt engineering now, and for me, this is a difference in degree, not kind, from what we do every time we talk to a new associate. If I'm talking to a client, if I'm talking to a paralegal, if I'm talking to a senior associate, a lawyer, you modulate, how you say what you're saying and how you put your thoughts together. You take feedback back from what you get, you adjust, you make sure you're communicating, and you test what you get. It has to be in accordance with your priors. So, it's just doing an amazingly good job of this. And then on the prompt engineering, yes, there's simple rules you need to do to make sure that you're talking to it the way it wants to be talked to. But that's another matter from thinking you need to go off and get a PhD in prompt engineering. I mean, you're off into engineering and development pretty quickly. So I think the role for us lawyers is more similar to what we did with Westlaw, which we now do with the search things. I mean, we take search terms, we negotiate those all the time. We change them around a little bit, we put them in, we get different outputs. So I think it's the same thing we're going to have with the GenAI tools, but it's just way, way better.
Yeah. And so you would tell me, what else would I tell my students? So it was probably getting us a little away from e-discovery per se, but our clients are going to be using AI tools. And so we're already seeing lawsuits. Some clients are using AI tools to do initial vetting of applicants for employment. There's an allegation that an insurance company was using an AI tool, and as a result, insurance rates were being discriminatory. There's another lawsuit currently pending in the United States where the insurance company allegedly was using an AI tool, and the AI tool was predicting what was going to be covered and not covered under the insurance plan. And so all three of those cases, what they have in common is were the data sets that were used in creating the AI tool discriminatory in some ways. And so I think law students and lawyers need to know, not so much for the e-discovery world, because I don't see a lot of problems. You correct me if I'm wrong. I don't see a lot of problems with bias for use in e-discovery, but it could
not that I've seen. I agree.
Yeah, so but there could be bias for other purposes. So if you're representing and they're using an AI tool to do the initial vetting of candidates, well, we got to figure out how was the system trained? What data sets were used? If it was all basically trained on individuals who are white, well, then the system may be skewing that way, and maybe unintentionally, but in fact, screening out Blacks or minorities who are qualified. And so we have to worry about stuff like that. And so I am teaching my students about perhaps the potential of bias in the systems. There's one case that this is almost like 10 years old now, I think, but it illustrates the concept really well. Somebody created something called Compass, and it was created for some other purpose, but at one point, some states were using it as basically an early AI kind of a tool to determine who should be qualified for bail or not be recommended for bail. And talk about the importance of how these tools are trained. In the training set was zip codes. And so you would think, what's the big deal? Well, in the United States, zip codes have a high correlation with race. And so, again, these tools don't intentionally discriminate, but the tools somehow learn that, okay, well, these zip codes have high recidivism rates. And so what was happening is Black individuals charged with a lesser crime and who had a lesser criminal history were being denied or were being recommended not to be given bail, but whites with a greater charge being alleged against them and with a greater criminal history were being recommended by the tool to be granted bail. And so it's garbage in, garbage out. So we need to perhaps sometimes understand what's going on, but how are we going to get some of these questions answered? I think that's going to be a little problematic. And so we're going to have to keep an eye on regulatory actions that start occurring at some point here. There's some talk about the government requiring AI developers to be a little more transparent about their training and their algorithms. There's probably going to be pushback on that, understandably, for proprietary concerns, but there'll probably be something out there about, transparency and some acknowledgement of what the training set was used. Going back to, people might not remember what I had on the first screen. So let me go back. I went to Dolly and I asked them the prompt was something, I don't remember the exact prompt, but it was something to the effect of provide for me a graphic illustration of a futuristic lawyer practicing law in the United States. Something to that effect. I don't remember exactly. This is what gave me. So it gave me a male. I mean, was the training set discriminatory? Don't know. Generally, it could provided me a male or a female. And so it had a 50-50, I guess, sort of idea of what to produce, and it produced a male. Was that because of bias or just randomness? Don't know. The feature here appears to be something of an Asian gentleman. It's like, is it the training set had more Asian looking individuals in the training set? And is that why it skewed that way? Or was that random? Don't know. got a lot of gadgets on it.
I think Google and the other ones have programmed that in to a certain extent as well to get an artificial dispersion or just distribution of different racial characteristics and stuff that they want to have those in the images. So that's part of that as well.
And so recently, last week or so, right, found out that these AI art tools were actually trained to be more inclusive, as you just said, and actually had test Nazi troopers who were black, which was completely historically not possible. And so we're going to have to ask a lot of questions about how these tools were developed. Do we have to ask them for everything? I don't know. Like in the e-discovery world, I'm not sure we're going to be as concerned about bias, but if we're using them for tough decisions, we're using them to hire somebody, we're using them to decide whether or not somebody gets some healthcare treatment. There's going to be a lot of questions asked about all that stuff. And we as lawyers are going to have to up our game about asking questions.
Well, that's probably a good breaking point. I could really talk about this for the next 5 hours, but I think we have to keep these at things. I think we have addressed some of the issues and have at least had some discussion on some of the things that are up, and that's all. You can't boil the ocean on this. There's going to be so much. Was there anything else you wanted to mention or close with before we break off this session?
The only thing I will close on is, I'm really impressed with what the medical community is doing. I'm going to give you all these slides. There's a lot of, I think, helpful information in here as well. But in sort of closing, though, the medical, I made an allusion to this earlier. In the medical industry, they have used AI tools that are doing a better job of detecting early forms of cancer than what radiologists can do. This has already been proven. And it makes a lot of sense when you think about it, right? They got all these MRIs, all these CT scans, and all this stuff that they've absorbed. And it's doing predictions, and what these machines are real good about is finding anomalies. And so they can find these anomalies at scales that the human eye is currently not able to detect. And so they can find abnormalities of recent cancer that radiologists may not detect. And so that's a good thing. We ought to be celebrating that. And so we shouldn't be, as lawyers, so fearful of this stuff that, oh no, it can't be used in the legal industry. We're too important. We're too sacred. As long as we're embracing this with caution, the medical industry, I think, is leading the way, and we in the legal industry need to follow.
Just couldn't agree more. A wonderful point. Well, we'll wrap it up with that and turn it back over to Jeff. Judge Rodriguez, thanks again for spending the time with us, and just really interesting. I'm sure this is going to be well appreciated and inspire a lot of discussion, with our followers. Thank you.
Thank you.
Thanks, Gene, and thanks, Judge Rodriguez. That was an excellent presentation on how GenAI is impacting the legal landscape. At Lexby, we've launched 2 GenAI e-discovery products. Lexby Copilot is the first one, which is a secure integration with GenAI large language models and our Lexby e-discovery platform. And this helps you automate a bunch of different e-discovery functions. It really is amazing how powerful Lexby Copilot is in helping you get that early case assessment that Judge Rodriguez was referring to. You can analyze a single document, multiple documents, or your entire case. As you can see, all of these use cases, you can automate document review for responsiveness, you can summarize documents, you can automatically identify key events, entities, and issues. You can automatically create a timeline of events. You can have it define acronyms, which can be very helpful, especially in acronym-intensive industries like telecommunications. And in the example to the right, you can see that Lexby Copilot analyzed medical records and listed all of the treatments, the medical providers, the purpose of the visits, and more. Our next GenAI product is Lexby Autopilot. This takes technology-assisted review and continuous active learning to a whole new level. Not only do we provide you with the prompt engineering, but we track the critical metrics that Judge Rodriguez referred to during his presentation. In addition to precision and recall, we also provide a confidence score, and the rationale for the predictions as Gene had talked about. This is a lot more efficient and cost-effective than TAR and managed review. If you've got a document-intensive case, or if you're up against a deadline, Lexby Autopilot can certainly be a lifesaver. And with that, I'll ask our last polling question. Would you like a demonstration of Lexby's GenAI-powered e-discovery platform? All right, and I'll go ahead and close that poll. We work with a lot of litigators to help them solve their e-discovery problems. Jordan Howlett is a sophisticated litigator running a multi-office firm. Most of his cases involve larger, well-funded opposition. With Lexby, he likes having the GenAI integration available at his fingertips so he can quickly gain insights into the relevant case documents. David Jones was concerned that he would be outgunned by his AmLaw opposition. He quickly realized that Lexby was a great equalizer and helped him build his best case that delivered a winning verdict. Paige Tackett at Thompson Co. needed Lexby's speed to get productions out the door faster to meet deadlines. Lexby is lightning fast and gets you from document ingestion to productions faster. Patrick Biggins needed an easy-to-use e-discovery platform to handle document-intensive cases. Lexby got him onboarded fast and provided the support they needed to build a strong case. We'll be making the following available to webinar attendees: a recorded streaming version, an MP3 podcast, as well as a PDF. Please let us know if you have questions or comments about this webinar or suggestions for future topics. This webinar is part of the Lexby e-discovery webinar series. For notices of future live and on-demand webinars as part of this series, please email us at webinars@lexby.com or follow us on LinkedIn. Also, we'd like your advice regarding our webinar series. Please complete the survey at the end of today's session. It helps us continuously improve this program and cover the digital forensic, GenAI, and e-discovery topics that are most relevant to you. And thanks again to Gene and Judge Rodriguez for presenting today, and thank you for attending. Be sure to follow Lexby on LinkedIn so you'll be alerted to the latest podcast and webinar episodes, and watch your inbox for an invite to our next webinar on best practices in e-discovery, AI, and digital forensics. Take care.